Thank you very much. If I may, Jerry, it's a pleasure to be joining you today. Before I begin, very much congratulations for putting on this fantastic program over this week. One that a variety of my colleagues here at the UNCITRAL Secretariat are taking a keen interest in. And I'm delighted that UNCITRAL Secretariat was able to present at the start, as well as towards the end of the panel and towards the end of the session. And here you have me in between to be talking about the ongoing work at UNCITRAL in the area of the digital economy. Allow me just to begin my presentation by giving a bit of background to myself. I am, you may tell from the accent from some in the room, unlike my surname, I am an Australian lawyer. Actually, I have a background in public law and public international law, and I know, Jerry, you'll appreciate the different take that that has for questions of private law and private international law in this area of the digital economy. The second thing I wanted to flag is that I am a former legal officer of the Permanent Bureau of the Hague Conference, which so I've jumped from one sister organisation to the other sister organisation, and with that I'm hoping to provide some views about the connectivity between what is happening at UNCITRAL at the moment in this space, and also what is planned to happen at the Hague Conference, or indeed what has been outlined for possible future work at the Hague Conference in the documentation for this year's Council on General Affairs and Policy. Now, the next point I wanted to also say before getting into the substance is just to give a brief overview of UNCITRAL itself as an institution. I gather from the audience here that some are very well familiar with UNCITRAL as an institution, but at the same time, there may be those in the room who are more focused on the tech aspects and on the legal aspects and may not be so concerned about UNCITRAL as an organisation. So that makes my task a bit difficult to pitch who we are as an organisation. But as the Secretary General, Christophe Bernasconi, outlined in his opening address with the tripartite address with UNCITRAL, UNITRAL and the Hague Conference on Monday, the UNCITRAL, as he outlined in that presentation, UNCITRAL is a organisation made up of, represented by member states, and these member states are United Nations member states. A bit different from the Hague Conference and UNITRAL is the fact that we are a body that's set up by the General Assembly of the United Nations with a particular mandate to harmonise law related to international trade. And so UNCITRAL as itself is a body made up of member states, and UNCITRAL does its work through working groups. And these working groups are bodies which are made up of those same member states, which meet twice a year to tackle different questions of in relation to international trade law. These relate to matters such as international commercial arbitration, insolvency, secured transactions, and one key area that UNCITRAL has worked in over the last 25 years and more is digital economy, and in particular electronic commerce and electronic transactions. So here that where the substance of my presentation will kick off, and that is regarding the current work that we have at UNCITRAL on legal issues related to the digital economy. Back in 2018, the UNCITRAL Secretariat was given an exploratory mandate to look into legal issues related to the digital economy. And for those seasoned observers of the three sister organisations, as they will note, a similar exploratory mandate was also being put to the other two organisations, UNITRAL and also the Hague Conference, to look within their respective mandates at what the new digital tools that are being used in private transactions, what these mean for their respective mandates, the existing instruments that they have, and the potential need to fill gaps in the current legislative fabric to promote the interests of of traders, of private parties in their civil and commercial interactions. So for UNCITRAL, the idea was to focus, of course, on the trade-related aspects. And it's here that we embarked on a taxonomy exercise to really identify what are the areas that are engaged by these new tools of digital trade, and to see exactly answer that question. Is it what we have sufficient? Are there gaps? And how can those gaps be filled in the organization? And I note that a similar theme is quite pronounced in this CODIFI conference, in that it's both looking to possible future work, but also the separate track in looking at what the existing Hague Conventions do to and how they can apply or be adapted to apply to these new tools of digital trade, digital interactions between commercial parties. So the first step that we as the Secretariat did was this taxonomy exercise. And for that, we identified 5 discrete topics. And these topics you will have heard quite a bit already on this program. The first being artificial intelligence. On that, and as I'll outline the methodology for the taxonomy, we realized that a lot has really got to do with automation. So what started as looking into artificial intelligence moved to looking more into questions of automation, of course, including questions of artificial intelligence and its deployment in trade relations. The second one is data transactions, which I have to admit that when I looked at to begin with, personally, I was scratching my head as to exactly what this means. But as the topic and as our research has unfolded, there are certainly discrete legal issues in here relating to the cross-border trade in data. The third aspect is digital assets, and I note that colleagues from UNITRAL will be joining us later today to provide an update on the status of the project at UNITRAL on the private law aspects of digital assets. The fourth being online platforms or digital platforms. And the fifth topic that we were looking into for our taxonomy is on distributed ledger systems, or systems that run on distributed ledger technology. And in this regard, I found very informative the presentation earlier in the week, the discussion that was had with the council from the Ethereum Foundation about some of the legal characterization and discussions about distributed ledger technology. Now, that last point really emphasizes a key role that we saw ourselves playing in this space as a secretariat, and that is about characterization. A lot about this is trying to characterize in legal terms to a legal audience what each of these areas mean. So in particular, with artificial intelligence and automation, we quickly saw that this is a field that subsumes questions related to smart contracts, which is a term that is often assimilated or is often associated with distributed ledger systems. But the more we looked into it, the more we found that this is something true to the notion of technology neutrality, something that really rightfully should be addressed in the topic of automation. Also other characterizations such as digital assets, and a realization for us that the recent work that UNCITRAL had done on electronic transferable records was essentially an entree into the world of legal aspects of digital assets and questions of control and transferability, which we see playing out in the current discussions regarding the private law aspects of digital assets. So before going any further, the methodology that we applied for this taxonomy, which really would have informed the current work that is ongoing at UNCITRAL, is firstly to identify what each of these topics means in a legal sense. What is data for the purposes of the data transactions? What are the transactions that are taking place with data? We have data provision contracts. We also have data processing contracts, and each of those have different legal issues that are raised. The digital assets. What are we talking about with digital assets? Online platforms, the notion that this is essentially digital services that has an intermediary involved. So identifying common legal relations that underpin online platforms. And finally, with distributed ledger systems, understanding as much as we could as mere lawyers, what is at play with distributed ledger systems. How do we define them in legal terms? And in particular there, and with the other areas, looking at domestic legislation that has been enacted in the last decade or so, with a view to regulating or indeed promoting the uptake of these technologies. But also legislation in the field of in regulation, looking at not only going to promote the uptake, but also legislation that's looking into regulating certain aspects or certain activities that are undertaken in reliance on these technologies. So that was the first aspect of the methodology with this taxonomy exercise. The second aspect was then to identify what are the legal regimes that are engaged by these tools as we have defined them. And we're really focusing mainly on areas within the UNCITRAL remit, in particular on the impact of these tools and technologies on questions such as contract law, property law, questions of secured transactions, insolvency, and the like. And it is here that we are, and I should note that this taxonomy, although we have done a preliminary draft of it, it really does depend on, you can see the need for inputting from the Permanent Bureau and the Hague Conference. And this is where we also rely on that coordination between the two organisations, because indeed, as has been flagged in the preliminary document that was submitted to the Council on General Affairs and Policy, there is a certain private international law aspects of each of these areas that has been identified in that paper. So it would be remiss for the UNCITRAL Secretariat to finalise this taxonomy without having that very valuable input from our friends in The Hague. So that's the second stage in the taxonomy, looking at the legal regimes that are engaged. And then another one is also looking at the legal actors. In a way, that's something that I should have mentioned before going to the legal regimes. But who are the players who are engaged here? Is it just the commercial parties, or are there other third parties that are implicated in the deployment of these technologies and the various tools that they support? So that taxonomy project is something that for which we have done a preliminary draft on each of those five topics and presented it to UNCITRAL for its consideration. And indeed, we have used that as a map to guide looking to the next phase in our work to identify those topics that could lend themselves most to work being done by UNCITRAL, with a view to filling any of the gaps that have been identified in the existing international legal regime. And in that regard, there were two topics that we had flagged that as being the forerunners, or as a term which I found out it's a bit specific to Australia in a way. It's the first cab off the rank. And here we look at automation, and in particular, the use of automation in contracting. And the second one, data transactions, and in particular, contracts for the provision of data. Now, the reason why we see these as being the first cabs off the rank is that we identified that potential future work in these areas really does build on existing work or existing legal texts that have been developed by UNCITRAL in the area of automated contracts. We saw it here at the Secretariat that it really does build on the existing work that UNCITRAL has done in electronic commerce and electronic transactions. And it is here that I would single out the 1996 Model Law on Electronic Commerce, the 2005 United Nations Convention for its short name, the Electronic Communications Convention. And together, those instruments have been widely enacted. The success of these instruments was already noted earlier in this week, and we saw that the provisions in these instruments already provide somewhat of a foundation for developing more specific, more targeted, and more up-to-date rules addressing questions of automation in contracting. And just to give a quick idea of the problematic that we're seeking to address here, and you would have, some of you in the room will have seen this in the context of smart contracts in particular, but questions such as whether parties can rely on the output of automated systems for the purposes of expressing their will with respect to a contract. So can you enter into a contract using the output of automated systems, given a certain remoteness between the party in either programming or operating the system and the actual output on which they may seek to rely to say, here is where here is the contract, here are the terms of the contract, or here is how the contract is embodied in the form of computer code. That's one question, but also other questions related to, and I think this is where, in my view, smart contracts really come into play, as in the performance of contracts. So not so much in the formation, but really in the performance of a contract. And questions do arise as to the extent to which you can use automation, or the issues and the legal issues that this raises in the performance of contracts. And here we've seen two schools of thought. One is this is just a matter purely of the party, for the parties. Party autonomy will dictate that the parties can use automation if they wish to use automation. On the other hand, we see legislative developments around the world trying to address some of the legal concerns with regards to the use of automation in the performance of contracts. So what we have put together in terms of a proposal at the Secretariat is to try and identify where existing UNCITRAL instruments are relevant, and in particular the Model Law and Electronic Commerce and the Electronic Communications Convention, and then to identify how perhaps the principles underpinning these instruments may guide addressing identified gaps in the application of those instruments to specific questions of contract automation. And in that regard, this was a proposal that the Secretariat put to to UNCITRAL, to the Commission, when it met in July this year, and we now have a new mandate that has been given to UNCITRAL Working Group 4, which is a working group that has for many decades now been focused on questions of electronic commerce, has been given a mandate, a two-stage mandate, to address those legal issues with respect to automated contracting. The second area being data transactions, and this is the one where also a mandate has been given to the working group to look into the legal aspects of data provision contracts. And again, it's an area where we can find some inspiration, probably less so reliance, but inspiration by past work done by UNCITRAL in the area of the international sale of goods, given some analogy that can be drawn between cross-border trade in data and cross-border trade in goods. Although I don't want to overstate that connection or that analogy, but in any case, it provides us with a useful tool in identifying what are some of the legal risks or the legal issues that for which a harmonized legal solution may be desirable. So they are the two areas, automated contracting and data transactions, that our Working Group 4 will be looking into. And the first session of Working Group 4 will take place at the end of October, the 31st of October to the 4th of November. In my final point that I'd like to make is about the complementarity with future work and the work of other organisations, and in particular, some of the constraints that this poses on our mandate. When I have conversations with people about use of AI and automation, of course, people think immediately of ethics and governance in AI, which is a hot topic within a number of international forums. Certainly, we're not looking at being another forum for discussing these issues, but rather seeing as how we can factor those guidelines into or the output of those processes into the legal rules that we develop. Another one is, of course, in data. Personal data protection is a key issue, and one that is increasingly becoming the topic of international discussions, in particular in the Joint Statement Initiative on Electronic Commerce that is taking place in Geneva, with Australia, Singapore, and Japan as co-conveners. And of course, we're wanting to say we're not here trying to develop new protections for personal data, but rather provide a base layer or a base legal understanding about data and its exchange and transactions in the commercial world. Of course, acknowledging that particular protections may exist, and certainly not wanting to oust those or create new protections, but rather accommodate those as may be needed in each jurisdiction. And so there's a complementarity there between what we're seeking to do and what parties are seeking to do, say, in that Joint Statement Initiative on Electronic Commerce, but also a certain complementarity with processes at UNITRAL and Hague Conference. And in closing, I wanted to just restate the importance of this tripartite collaboration and cooperation. In particular, what was mentioned at the start of this conference about the tripartite collaboration on the Guide for International Commercial Contracts. And as you will see from this presentation, the two areas of work that are going forward with at UNCITRAL, data transactions or data provision contracts to be specific, and automated contracting all have that common element of contracts. And as soon as we start talking about contracts, of course, we have questions that are relevant for both the mandates of the Hague Conference as well as the mandates of UNITRAL. And so we very much look forward to continuing our work together with those organisations and to see how their respective mandates may well fit into the output of the work being done at UNCITRAL. So with that, I'd like to thank the organisers and particularly you, Geraldine Goescalar, for the invitation to present here. And I wish all participants a thoroughly enjoyable and fascinating conference. Thank you very much.